Hello, students, and welcome to the lecture. So, students, as we noted, we have started the discussion over the fundamental rights. Okay, and basically, in the previous lecture, we had concluded our discussion over the Article 30. All right, and basically, we have discussed that Article 30 stands for the right to minorities to establish educational institutions. Okay, that's the thing what we had discussed. So basically in this lecture, we will start from where we had left in the previous one. All right. And this is the thing that we are going to see here. Okay. So basically now what we are going to see, that we are going to see the constitutional remedies. Like what is that? So basically if we talk about it, so we know that there are three types of democracies we practice in India. Okay. The one type is the political democracy. Second type is of the social democracy. Third type is of the economic democracy. Right? That's the thing. And then we know that the political democracy is basically promised by the fundamental rights, whereas the social and the economical democracy promised by the directive principles of state policy. Got it? And we know that one of them is not, okay, let me write down again. One of them is not enforceable in court, while the another one is unstable in court. Right? So now the thing is, if something is enforceable in court, so it means that the thing will have the constitutional backing or constitutional provision, right? That will be the thing. So that's why if the something having the constitutional provision or backing to enforce something in the court, which means that there must be some particular article to deal with that particular thing, right? There must be some particular article. So what is that particular article? That's the thing. So that particular article is Article 32. Okay. So Article 32 is the article which you can say provides a provision through which the fundamental rights are enforceable in the court. And this particular article is known as the constitutional remedy. Okay, that's what we are going to see here. Got it? So basically, this is just an basic overview. This is just an, you can say, build up or the plot, so that now you will be mentally ready to understand that what we are going to see. Okay, so let's start. A mere declaration of fundamental rights in the Constitution is meaningless, useless, and worthless without providing an effective machinery for the enforcement if and when they are violated. Like when we had discussed about the fundamental rights, or you can say when we were discussing about the DPS. Okay, so the one thing was clear, that DPSP principles are there, but these principles are not so much effective. Why? Because these are on the discretion of the government. Discretion of the government means that if the government would like to make the provision law and act on it, then only the provision will be implicated. If the government do not want to do any kind of thing, the provision will not be implicated. All right. So if the similar thing which happened with the fundamental rights, so what do you think? Is there any need to make the fundamental rights meaningful, useful, or worth it? No. So if there is nothing like this, so the fundamental rights having nothing to do with enforceability. So that's why there is an Article 32 in the Indian Constitution. This particular article confers the right to remedies for the enforcement of the fundamental rights of an aggrieved citizen. It means that if any citizen thinks his or her fundamental rights have been hurt out, that person could move to the court for the enforcement of that particular fundamental rights under Article 32. Okay. In other words, the right to get the fundamental rights protected in itself is a fundamental right. It means that the Article 32 stands for the constitutional remedy is a particular article, and it's a particular fundamental right, so that it is not easy to abrogate or bridge away this. Why? Because it is fundamental right itself. This makes the fundamental rights legal. It means that the fundamental rights are enforceable by the virtue of Article 32, and Article 32 itself a fundamental right, so it could not be abrogated or bridge away from the citizen. Okay, this is why Dr. B.R. Ambedkar said or called Article 32 as the most important article of the Constitution, an article without which there is Constitution would be nullity. Why? Because the Constitution promised the political democracy, all right, and this political democracy have been ensured by the fundamental rights. And even if the fundamental rights are not enforceable in the courts, then what will happen? There is no meaning of providing the fundamental rights here. And fundamental rights providing Article 32 itself a fundamental right, so there is a security, okay, and there is a surety that the fundamental rights will be implemented. Okay. Thereafter, if we move forward, so What is that? It is the very soul of the constitution and very half of it. Who said this? Doctor B.R. Ambedkar said. Okay. Thereafter, a Supreme Court has ruled out that Article 32 is a basic feature of the Constitution. So it means that it could not be amended. Like we know, if we talk about it and if we try to do a little bit revision of it, so we know there is an provision of amendment or making constitutional changes in the Constitution, right? We know this. And basically for this, if we talk about it in real form, so there is an Article 368. Article 368 says that the Parliament, if needed, could change the provisions of the Constitution under the Amendment Act. Alright, but regarding this, there is a very famous case of Keshav Nanda Bharti case. Okay, which was happened in 1973. So in the Keshav Nanda Bharti case 1973, what happened? Like for the first time, the concept of basic structure of Constitution ruled out by the court officially. By the courts officially. All right. So that's the thing. And thereafter, we know there is a very famous thing, which is the judicial review. Okay, like we know, the courts having the power, all right, so that they could exercise the power of judicial review and they could review the legislation and the impact of it. All right, if it is against the constitutional provision and harming the basic structure of the Constitution, then the provision will be removed by the court. All right. So to overcome this power judicial review, what happened? That there is a Schedule 9 passed by the government. All right. And basically the Schedule 9 states that if something put under the Schedule 9, then the thing is totally exempted from the judicial review. Okay. Like no judicial review could be happen on that. So to overcome this, basically in the 1973, during the basic structure case, the Supreme Court ruled out that whatever the things have been transferred to the Schedule 9 after the 1973, these things could be checked under the judicial review. The things shifted to the Schedule 9 prior to the 1973 would not be checked under the judicial review, but after 1973 would be checked under the judicial review. So similar thing was happened there after doing the revision. Now we can come here. Like Article 32 was also declared as a basic structure of the Constitution so that it could not be amended. Hence, It could not be abridged or taken away even by the way of amending of the constitution. Okay, so basically it contains the following four provisions. The first provision is the right to move the Supreme Court by appropriate proceedings of the enforcement of the fundamental right is guaranteed. Okay, like if any person, he or she, believes that his or her fundamental rights have been deprived of, then the person could move to the Supreme Court, all right, and by the appropriate proceeding or by the procedure established by the law, there is a guarantee that his fundamental rights would be enforced again. Thereafter, the Supreme Court shall have power to issue directions or orders or writs for the enforcement of any fundamental rights. Writs issued may include the habeas corpus, the mandamus, prohibition, certiorari, and quo warranto. Okay, to ensure that there will be a implication of the fundamental rights, enforcement of the fundamental rights, the court could issue these writs like habeas corpus, mandamus, prohibition, certiorari, and quo warranto. All right. The parliament can empower, if we talk about it, the constitutional provision. Then remember, the constitutional provision basically empowered the Supreme Court to enforce the fundamental rights, issue writs and all. All right. But it is depend upon the parliament also. Like they could empower the other courts also to issue the directions, orders and writs of all kinds. However, this can be done without prejudice to the other powers conferred on the Supreme Court. It means that only the delegation of enforcement powers of Supreme Court would be transferred. Only delegation of enforcement powers of Supreme Court would be transferred. Okay. But remember, no complete transfer of powers would be there. Okay. It means that for the few time the delegation would be granted from Supreme Court to other court, but no complete power. It means the Supreme Court power of enforcing the fundamental rights that could not be prejudice. Okay. Any other court here does not include the high courts because Article 26 for 226 has already conferred these powers on the high courts. All right. Because we know in India there is a 3 court systems, or you can say 3 levels of court system. Supreme Court at national level. Then comes the High Court at state level. And then comes the subordinate courts at regional or local level. Okay. So if we look at it, so remember Article 32 provides the power to the High Supreme Court. Thereafter, Article 226 provides the power to the High Courts, and basically the Parliament is entitled to granting the power to the subordinate because the other two articles already doing this thing. So there is no need to pass some separate act and then transfer the powers to the High Court. All right. Thereafter, the right to move to the courts, Supreme Court, shall not be suspended except as otherwise provided by the Constitution. Thus, the Constitution provides that the President can suspend the right to move any court for the enforcement of fundamental rights during the national emergency. Okay, please correct it. It is not 359, it is 352. Article 352. So basically, if we talk about it, so we know that in India there are the three forms of emergency power. Okay, like first is national emergency. Thereafter, state emergency. Thereafter, financial emergency. So the national emergency enforceable by Article 352. State emergency enforceable by Article 356. Financial emergency applicable by Article 360. So remember, always whenever there is a national emergency is in the force, it means Article 352. So fundamental rights will be suspended. Fundamental rights will be suspended except the two rights. And what are these two rights? Which two rights could not be suspended even during the emergency? So to answer this question, you have only 20 seconds, then I will give the answer. So your time starts now. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13, 14, 15, 16, 17, 18, 19, and then 20. So basically these two articles are Article 20, right against detention and arrest, and Article 21, right to life and personal liberty. Okay, these two articles even during the emergency could not be suspended. All right, and rest of the fundamental rights will be suspended, including the Article 32. Okay, so if you think that anything happens to your fundamental rights during the national emergency in force, so by using the Article 32, you could not move to the courts. Why? Because there is a power given to the President of India. Okay, like he could suspend this right for you. All right, that is the thing. And basically, if we talk about suspension of the fundamental rights during the national emergency or the emergency provisions, so remember that this is the borrowed provision. Which means that this provision was not developed in India. Okay, we had borrowed it from somewhere, and the place where we borrowed it was the Weimar Constitution, which stands for the German Constitution. All right, so that's the thing. So it is thus clear that the Supreme Court has been constituted as the defender and guarantor of the fundamental rights of the citizen. That's why it is oftenly described as a guardians of the Constitution, as well as defender of fundamental rights. So it has been vested with the original and wide powers for that purpose. Okay, original powers means which are constitutionally granted. Wide means conferring the powers becomes necessary. Okay, so that's the thing. So students, basically in this lecture, we have covered till here. In the next lecture, we will continue from here. Till then, just revise the facts and figures that all we have discussed in this lecture and be ready for the another lecture. With this note, let's end this lecture. All right. But before ending this lecture, as I have told you, that you are required to revise the facts and figures. Why? Because there are so many things that we have covered here on. Okay. The article 32 seems like a small article when we just overview it. But when we talk about the implications, when we talk about the cases, and whenever we try to put it in the real scenarios, then it's become tricky. All right. So if you do not want to be get messed up while you are pointing while you are attending the tricky questions, then you are required to prepare it first. Okay. So this is my advice to you. Just follow it. So with this note, let's finally end the session and thank you.